Goldstein, for those of you who don't know, she's the new Deputy Attorney General under Peter Neronha. That's the third new job you've had in the last 3 or 4 years.
Can't hold a job.
Can't hold a job, yeah. Well, congratulations.
Thanks.
The first Deputy Attorney General I served under when I was in the Attorney General's office was the first woman that ever held that job, Judge Susan McGurl. Yeah. So I think you're the second. Congratulations.
Thank you very much. I had lunch with Judge McGurl the other day.
Yeah.
She tried to impart all of her wisdom upon me. See how I do, but
Do fine.
forward to it. Thank you very much. Thank you very much, Chairman Craven and members of the committee. I'd like to begin also by thanking all of the sponsors of the Attorney General's bills and Governor Raimondo bills that are being considered tonight. It's my honor to speak on behalf of Attorney General Neronha and the Attorney General's office. As Attorney General Neronha has said a number of times, and my colleagues here around the table have said, there's not a single bill, policy proposal, or set of proposals that is going to solve the problem of gun violence in this country. And I have spent countless hours working together with Colonel Manny and with Dr. Megan Ranney on the Gun Safety Working Group, where we considered and studied numerous proposals, combed over data, combed over legislation in other states and federal laws to come up with a set of proposals, many of which are before the committee tonight. And I'd like to thank the committee for grappling with these proposals and asking a lot of very probing questions, some of which I would like to attempt to answer tonight. And I'm going to split my testimony with our Bureau of Criminal Identification Chief, Ed Troiano. Mr. Troiano is a retired agent of the ATF. He is an expert in federal firearms laws, federal firearm law enforcement, and I think he's going to speak to a number of Attorney General, the bills proposed by the Attorney General that are specifically targeting criminal use of firearms in the state. I'd like to begin by speaking about the high-capacity magazine ban. This legislation would ban all firearm magazines with capacities exceeding 10 rounds. The legislation is important because in the unfortunate event of an active shooter situation, every second counts. And the fewer rounds a shooter has to fire means that he or she would have to reload more often, giving a person either a chance to attack that shooter or to run away. Is it going to solve the problems of mass shooting? No. Could it potentially save a life? I believe it can. I hope tonight you're going to hear from Major Jagoda, who was one of the responding officers to the Sandy Hook shooting. I've had the opportunity to listen to him to speak about his experiences in responding to that shooting and what he witnessed there. And based on his experience and based on the experience of numerous law enforcement officers that I have spoken with, they believe, and the working group unanimously endorsed this proposal because it is a life-saving proposal. Next, I would like to speak in support of H.R. 5741, the Assault Weapons Ban Act. Again, this legislation would ban semi-automatic assault rifles, shotguns, and pistols that meet the features tests within the law as set forth in that act. It is based on the federal assault weapons ban and assault weapons ban legislation in a number of other states that have enacted it. And we believe, again, that these weapons of war simply do not have a place in civilian life. We recognize it is controversial legislation and that different people have different views on this legislation. We respect that. This legislation, as proposed, would also allow for the grandfathering of lawfully possessed assault weapons ban with certain conditions, again, that are set forth in the law. Next, I'm here to testify in support of the Safe Schools Act, which would ban guns in schools unless they're possessed by law officers and retired law officers. Guns have no place in school. There's been a very lively debate here in this chamber. You've heard about this legislation from Colonel Manny. And in the working group, during the working group, not only law enforcement, but superintendents, principals, teachers, mental health professionals who work in school all unanimously endorsed this proposal. And finally, I'm here to also speak about the Safe Storage Act. And again, the Safe Storage Act would enhance existing legislation in the state of Rhode Island by requiring that guns, when they are not directly controlled by the owner or not carried or in use by the owner of that firearm, be stored in a secure manner. This legislation is modeled on the laws currently in place in our neighboring state of Massachusetts. This legislation has been championed by public health professionals as legislation that is crucial to reducing suicides, to reducing access to firearms by children, by individuals who might be disabled, mentally disabled, or suffering from other mental health conditions. There's a lot of data out there about the tragedies that can occur when children access firearms that are not securely stored. Now, members of the committee, if I may address some of the questions that have been previously asked about some of these pieces of legislation. First, I'd like to begin with the questions regarding vehicles driving next to a school where a firearm may be held in that vehicle. First, I'd like to mention the fact that this legislation is modeled after the Federal Safe School Zone Act. And under federal law, a safe school zone actually extends 1,000 feet beyond a school. The legislation that has been proposed here is actually narrower than that. It's 300 feet around a school. It also contains certain exemptions, including the fact that the provisions of this law will not apply to the possession of a firearm on private property that is not part of school grounds or that is not loaded and is in a locked container or a locked rack in a motor vehicle. And so if an individual who is a permit holder, who's got a firearm, and they're driving to a school to pick up a child, as long as they leave that firearm locked securely within their vehicle, they will not be in violation of the law. I also want to address some comments regarding concealed carry permit holders and the benefits, the risks versus the benefits of having those individuals bring firearms within the school. Really, there's very little I can add to the testimony of Colonel Manny based on his experience. I think he captured it perfectly. I do want to point out that just as none of us can predict who is a good guy and who is a bad guy, whether a concealed carry permit holder will save the day, it is also entirely possible that a concealed carry permit holder can rue the day. The shooter in the synagogue in Pittsburgh, where 11 people were murdered, was a concealed carry permit holder. Children go to school to learn. Teachers go to school to teach. We have lucky in this state that we have many schools where there are highly trained, capable, highly regarded school resource officers who are present. We have police departments in the school that are accessible and respond quickly to schools to respond to any incidents there. Those are the individuals who should carry firearms on school grounds, nobody else. And finally, if I may respond to Representative Wilkinson's question regarding the safe storage bill, which I thought was a very probing and a very good question. I think that the issue that concerns you in that bill is your ability or a person's ability to quickly access a firearm in case of an emergency, and whether that bill would interfere with their ability to do so. And I don't believe that it would, simply because of the definition of what safe storage means. And it does exempt a firearm that is under the control of an individual. The intent of that bill is to address how firearms are kept when you or the owner or the user is not able to control that firearm, is not around that firearm, is not within easy reach of access of that firearm. And the intent is to make sure that that firearm is safely stored in those other situations so that it cannot be readily accessed by a minor or by another person who really has no business accessing that firearm. It also provides not just, you don't have to use a lockbox, you can also use a trigger lock or other mechanisms as well. So I hope I addressed some of those questions.
Yes, thank you. Go ahead. Leader.
Thank you. Thank you for being here tonight.
Thank you.
I'm curious, you raised the Safe School Act, I believe?
Yes.
Now, you had said the Safe School Act provides a 1,000-foot buffer around schools which firearms can't be brought in generally.
The federal law.
Now, the federal law provides an exemption for concealed carry permits issued by the state.
The federal law does provide for an exception consistent with state laws. That is correct. However, the vast majority of states do not have an exception for concealed carry permit holders. In fact, Rhode Island is one of only maybe 4 states in the entire country that has that exception.
But I'm speaking of the 300-foot buffer.
Correct.
The exemption you're talking about, I believe, is school property.
Yes.
Okay, so let's talk about that 300-foot buffer, because I think that's the rub here with this bill. I am a concealed carry permit holder, hypothetically driving down the road, and I think this question was posed to Colonel Manny. I would technically be in violation of this law as written.
Not necessarily. I don't believe that you would be, because
Okay.
the firearm would be, well, first of all, there is a question as to how would anybody know that, but
You get pulled over.
you get pulled over for, I guess, speeding or whatever.
Correct.
But if, again, the law provides an exception for firearms that are securely stored within a vehicle. And so I would argue that, you know, you may not be in violation of that law.
Okay, so
I will say, however, Representative Filippi,
Okay,
that if that is the issue that is of concern to the committee, we would be very happy to work with members of the committee to address that concern through a sub-A. I will say that one of the reasons for the inclusion of this buffer zone is because of the tragic shooting that happened last year right outside the Met School in Providence, where a young man was shot and killed right outside his school gate.
I understand, and that was a horrible tragedy, but I think we have to draft laws that can be practically applied without problematic application. I think a problematic application, and the exemption I think you were describing, if it's securely stored, and I'm reading it right here, that is not loaded and is in a locked container or a locked rack located in a motor vehicle. So you're a concealed carry permit holder, you're coming up on a school, the notion is that they would have to pull over, stop their vehicle, break down their firearm, or put it in a locked container. I just think, it's just not practical. It's unreasonable to impose that burden on people. So if the Attorney General's office is willing to redraft this with members of the committee to deal with this problem, I think we'd be happy to do that with you.
Sure, we'll be happy to work on that language if that is an issue of concern. in the
Maybe
law.
exempt
Absolutely.
CCW holders from the buffer. Thank you.
Numerous ways to address it.
Any further questions? Yes, Representative Place.
Mr. Chairman, I mean, she did testify in about 17 bills, so just wondering if I could just ask, there's a couple of questions, not
Sure, yeah.
too far, but if I may. I'm going to carry forward on Representative Filippi's comment. You know, as a concealed carry holder, if you're pulled over by a law enforcement officer, you have a duty to inform the law enforcement officer that you're carrying, but at the same time, you're not going to have it locked. So again, that's where we go to the concern And if they're coming onto the school property, if they're going to go to lock it in their lockbox, they're going to have to brandish the firearm in order to do it. So there's a whole series of steps that concealed carry permit holders have to follow to be within the rules without violating, getting in trouble with the colonel and his officers. But again, that's where I was going with my line of questioning, is that the 300-foot on school grounds, maybe inside the school building while attending events, I can understand, but the mechanisms of just picking up your kid or just driving by the road, I can think of 3 different schools in my community that are along major thoroughfares that someone could get themselves into trouble with. But again, that was just follow on with Leader Filippi. With the Safe Storage Act, how is the language in the Safe Storage Act differ from the D.C. legislation that was overturned by Heller?
I'm not familiar. I don't know exactly the legislation that you're speaking about. I think that legislation was not a Safe Storage Act. I think that legislation severely restricted the ability to possess firearms.
It did, but when they got into it, it talked about the firearms, but also said the requirements that a firearm in a home be disassembled or locked made it impossible for citizens to use their arms for core lawful purposes of self-defense. So I would ask the Attorney General's office while the Massachusetts law may not have been litigated, I would have to say that, I would like to answer that question as to whether or not that particular aspect, the safe storage law is actually constitutional. Because in Heller, there were 2 parts. Like you said, it was the elimination of a whole class of firearms, and then it was also the fact that if you happen to have it, you had to have it locked in a certain way, which would prevent you from using it, which is similar to the legislation that the Attorney General has presented to this committee. Second question I have, on the change from and this isn't your legislation necessarily, but I just wonder if the Attorney General's office has an opinion on this. On the change in the law to go from the age of 18 to purchase a long gun to the age of 21. Does the Attorney General have any concerns over the fact that this would bar a lawful legal citizen from purchasing a firearm or a whole class of firearms? Again, in concert with, we always talk about the Second Amendment. I mean, are we going to start putting age limitations on it? And that's where I'm just trying to wrap my head around this.
Well, Representative, regarding the age limitations, I do believe that the Second Amendment is fully consistent with reasonable regulations on firearms. Currently, there are age limitations. As you're well aware, you have to be 21 to purchase a handgun, a concealable weapon. That is an age limitation. Different age limitations apply to long guns. We are in support of it is not the Attorney General's bill, but we are in support of legislation to increase the age from 18 to 21, and that was a proposal that was also endorsed by a large number of the Gun Safety Working Group, of course with a number of reasonable exceptions for individuals who are in military, educational purposes, gun clubs, and a whole host of other exemptions, law enforcement. But I do believe that as to the constitutionality question, such age restrictions would be constitutional.
But we're going from a restriction to a full bar. And again, you go from barring a full, when you turn 18, you become a legal adult, you can vote, you can join the military. And again, I understand we have it for handguns already, but now we're completely barring it. And the constitutionality of that, in my mind, seems to be questionable, in the idea that, again, a law-abiding U.S. citizen can't purchase something that's within their, I think it goes beyond reasonable at that point when you go to a full bar. And again, I would ask the Attorney General's office to look into that prior, going forward.
Let me move on to another. Representative Canario?
Hi, thank you for your testimony.
Representative.
I'll ask you the question that I asked earlier. What makes 10 the magic number for the magazine round?
Sure. So I don't know about it being a magic number, but 10 has essentially been the number that was used in the federal assault weapons ban, and it's the number of rounds that is used in all the other states that have implemented a high-capacity magazine ban. So 10 appears to be, that definition appears to be consistent with the other states that have implemented high-capacity magazine bans, and again, formerly in the federal assault weapons ban.
Okay, so the Attorney General's office considers 10 rounds high capacity?
The definition of a large-capacity magazine ban would be defined as a magazine that is capable of accepting 10 or more rounds.
And whose
More than 10
definition is
rounds,
that?
excuse me.
Whose definition is that?
That is the definition that was previously used in the federal assault weapons ban, and it is the definition that is used in other states that have implemented this ban. Now, if you say, well, why not 12, why not 8? I suppose you can make that case. There are bans on the number of rounds that can be used federally for hunting purposes.
Yep.
For some, it's 3. For other hunting purposes, it might be 6. Any time that you are imposing a number limit, one could say it's an arbitrary limit, but that does seem to be a reasonable number, a number that has been used by many other states, and so there is a benefit to consistency across the board with our neighbors.
Okay. Well, let me first say, I don't believe that's a reasonable number, and I'll tell you why. Most semi-automatic handguns that people carry more than 10 rounds. Mm-hmm. Do you realize how many magazines there are out there that carry more than 10 rounds? Tens of thousands, hundreds of thousands.
Right.
New Jersey tried this. You know what happened?
Right. So, sir, Representative, I agree that there are magazines that carry large number of rounds. Could be 12, could be 15, could be 17. There are magazines that carry fewer than 10 rounds, 7 rounds. What this legislation allows is the modification of those magazines that carry more than 10 rounds such that they would come into compliance with this law. And there are implements out there, and again, I think my law enforcement partners who are seated at the table with me are far greater experts on this than I am, but there are implements out there that can be used to modify magazines to come into compliance with this law. There is another reason, Representative, if I may address it, which is for public safety purposes, most law enforcement, I believe, carry magazines that are higher, carry larger than 10 rounds. And another reason behind this limitation is, again, it is a law enforcement safety reasons. We do not want our law enforcement to be outgunned by individuals that they confront on the street.
Well, let me say this. There is no humanly possible way that this law will work. Never. There are too many, way too many, thousands, hundreds of thousands of those magazines out there. And do you think for 1 second that the criminals are going to modify or turn them in? Definitely not. But what's going to happen is the person who's law-abiding is going to be penalized because of the 10 number. Have you ever shot a firearm?
I have actually, sir.
So have you fired a
Colonel Manny took
have
me.
you fired a semi-automatic?
I have.
What kind?
AR-15 or 9mm.
We shot an AR-15.
And how many rounds?
I was too nervous to count, to be honest with you.
Well, my point being is that, again, most law-abiding citizens have more than 10 rounds in their possession, in their clip. I, for one, I carry, a off-duty all the time, a firearm that carries more than 10 rounds. Not just me, but I know an awful lot of people that carry more than 10 rounds. And it's not like you can say, there's 100 or 1,000 of them we can call back or have modified. It doesn't work that way. All you're doing is restricting the law-abiding citizen and allowing the criminals to have more firepower than you can defend. And I have a real problem with that legislation. That's my opinion. I think it's way off base, I think it's impossible, and I think it's just impossible to enforce.
I respect your position, Representative. I respectfully disagree. I think it has been implemented successfully in other states, in about 7 or 8 other states across the country. But I respect that people can have
It's
differing viewpoints
unenforceable,
on it.
but thank you.
Let's see if we, oh, I'm sorry, Representative Wilkinson.
Thank you very much, Mr. Chairman. I'd like to follow on with some comments regarding the high-capacity magazine bill. And the magazine restrictions are typically predicated on the belief that forcing more frequent magazine changes would reduce lethality, or as you said, you don't want the law enforcement officer to be outgunned. But in reality, the average magazine change takes approximately 2 to 5 seconds. And even if criminals were limited to the capacity of the magazines, they certainly wouldn't be limited to the number of firearms that they're carrying. So mass killing murders have shown that a common strategy isn't having endless large magazines, it's having multiple firearms so that when one runs empty, the criminal will pick up the next one and then start shooting. Now, I know that you had mentioned the federal study. I'm assuming that we were looking at the same one, the assault weapon and large magazine ban of 1994 to 2004. And it concluded that banned weapons and magazines were never used in more than a modest fraction of all gun murders, even before the ban, and that the law's 10-round limit on new ammunition magazines wasn't a factor in multiple victim and multiple wound crimes. So given this information, and again, the fact that you could have an individual that's carrying a number of 10-round magazines and change them out in 2 to 5 seconds, do you still see this bill as having any kind of an impact? I just don't see how limiting high-capacity magazines is going to have the public safety impact that you're seeking.
Well, Representative, I respectfully believe that there have been studies that have shown that high-capacity magazines have been used in the vast number of mass shootings, and both high-capacity magazines and assault weapons are the weapons of choice, unfortunately, of mass shooters. And while it is true that in terms of the overall number of deaths caused by firearms, mass shooting accounts for a small percentage of those incidents. As we all know from our all too recent experience, both after what happened in New Zealand just within the past week, what happened in Pittsburgh a few months ago, what happened in Marjorie Stoneman High School in Florida, in Las Vegas. These are profound incidents that kill and maim dozens and wound mentally, emotionally, hundreds of thousands of people, relatives, friends, neighbors, our children who watch television and see this happening all around them and who are scared to go to school because they don't know what's going to happen to them. And these high-capacity magazines have been shown in studies to account for a large number of these mass shooting incidents. And there have been numerous studies that, in fact, one of them, the Department of Justice, a 2004 study commissioned by the Department of Justice found that high-capacity magazines were used in crimes more often than assault weapons and accounted for 14% to 26% of guns used in crimes prior to the assault weapons ban. That Department of Justice study also found that firearms equipped with high-capacity magazines tended to account for a higher share of guns used in murder of police and in mass shootings. And so these implements do increase the lethality and the impact of these firearms. And if you take away their availability, I do believe it will have an impact on public safety in the state.
Could you please clear up for me what you're using as a definition of an assault weapon or an assault rifle?
Yes, so the definition is the definition that is in the proposed bill. It's quite lengthy. So probably going to need a bottle of water. If you just give me one moment, please. So H5741, which is the assault weapons bill, defines assault weapons in different ways depending on the category of firearm we're talking about.
Thanks for coming, Colonel.
Thank you, Colonel.
Sorry, I have to testify.
Oh, no problem. Thank you.
Would you like me to go through that
I have
definition?
it, I have it in front of me, thank you.
Okay.
Okay.
All right.
Thank you.
Can we go to Ed? Oh, I'm sorry. Yes,
Thank
Representative
you.
Roberts.
I just wanted to ask if any of you could, if any of you actually have any statistics showing the effectiveness of the Connecticut assault weapons ban by any chance?
I do not have that in front of me. If there are any studies, I'm happy to go back and forward additional information to the committee.
Okay.
I don't have anything.
Because in general, because of all these bills that keep being proposed to take away people's rights, I just want to, rights to keep and bear arms, I just want to read a couple of things that I have in front of me. One is that in New Jersey, no illegal magazines have been surrendered. In Connecticut, gun registration magazine limit law was ignored, and massive noncompliance with New York's safe law. And so I think that's probably what's going to happen here. I can almost guarantee that the people who are here to testify tonight are likely going to tell you that they're not going to comply. What is your plan for that?
Well, I keep hearing about law-abiding gun owners, so I assume that they will comply with the law, if that is the law that is being passed.
They're not going to, I'm sorry, they're not going to comply with their rights being taken away. This isn't a privilege, it's a right. So I think that's what they really want to get across loud and clear. It's not a privilege, it's a right, which no one has a right to infringe upon. Thank you.
Joe?
Thank you, Mr. Chairman. Mr. Chairman, it's a question for you.
Okay.
Is anybody here from the governor's office?
Well, I believe that two cabinet members, Colonel Manny and
Well,
Director Scott.
well,
But yes, as far as chief of staff or the governor, no, they're not coming.
all right, well, you corrected me on that. Maybe that's the way I should have worded it. So nobody like that is here.
Nobody like that's here.
So if it could be done the next time that the Black and Latino caucus gets notified of this commission, if in fact all of us are going to be sitting up here as state reps, the black, brown, yellow and red community would surely would have liked to have been a part of this a whole lot deeper. The good doctor from the Department of Health is great, but as legislators, the Black and Latino caucus should have been involved in this. The police departments are always sending me, they go out of their way to reach out, and I'm only going to speak for myself, of all the departments that are getting ready to hire, especially the state police, Providence Police. So I just put that out there so that we get notified as well.
Thank you.